situation of our client. The application was by us, our lawyers. That us lawyers have not received the report, but the court has maintained it. Well, albeit that sometimes these are private matters. It can only be a private matter if there is protest from the accused person, that it may not be disclosed even to the agents, not even family, because this is a report that the family, the mother, sister and other family members have requested for. So it cannot be a prisoner of court. It remains now really a mystery of whether. So
Council, we want to know the situation or the status of the accused people, basically Sauda Madada. What is the situation she is now and about the application that you've been raising in that case and the orders of the court?
Well, Sauda Madada was charged together with now 13 others, because the number has now risen up to 14 accused persons on the charge of unlawful drilling associated with the activities of the NUP headquarters. In that group, we have the security guards of the Honorable Robert Chagulanyi Sentamu. We have leaders of the party like the deputy spokesperson, Alex Waiswa Mufumbiro, the leader of the leadership school, Doreen Kaija, and among others who are even candidates in this election. Sauda Madada is standing for councillorship in Kampala Central Division. Doreen Kaija is standing in Nakawa for councillorship. The Honorable Waiswa Mufumbiro is standing for Member of Parliament in Nakawa East. So it presents a very precarious situation where you have candidates being in prison despite being entitled to mandatory bail. An application we made in court and it was denied. We have decided to review the decision against the mandatory bail before the Chief Magistrate, who is not yet at post, being a new judicial officer posted recently upon transfer to that court. And meanwhile, the prisoners believe they cannot get justice under the current trial magistrate, the reason for which they applied for recusal of the magistrate from their matter. That recusal application was made orally by one of the suspects, Alex Waiswa Mufumbiro. It was not granted in premises that they have to file a formal application. Shall also proceed to file a formal application as guided by court. Not that we not believe that it was properly before court, because such an application can be oral. It is an application which can even be made by a person who is not represented. So it was misconceived for the court to say such an application has to be formal, but nevertheless we shall follow that guidance. But there is a pattern that we are seeing. Most of these political cases, we've had over 1,000 supporters and members and leaders of the National Unity Platform since the election began. We've managed to bail out over 400. But if you realize, it depends on your stature in society. You have had so many out and others stay in. Others are not even accounted for. But we've realized that those who have the status in society are not released. So the ground is not leveled. It is upon your status that court determines whether you're a sensitive politician or not. It depends on the caliber of politician that you are in the NUP or in the opposition, and determines whether you'll be released on bail. It is no wonder that in the last decision against the mandatory bail application, the court had to delve into politics. It was very clear in its finding that because of the complex political situation prevailing now, it would be very hard for the court to agree to release these persons on bail. So court had to go that law into politics, determining matters based on politics rather than the law. We find it also, it cannot be a coincidence that all matters involving high political persons are being adjourned by court beyond the 15 days ordinarily, which is provided for in the regulations. But it's very clear that all these people it's a decision of courts that these people should not participate in the election. We see the Honorable Dr. Kizza Besigye's matters which were adjourned to 21st. We've seen Alex Mufumbiro in one of the matters adjourned to 22nd. His other matter with others, the one of Nakawa is 22nd, the one in Kanyanya is the 23rd. You see the Bukenya Mvawala matters being adjourned 22nd. We see Sarah Bireeta's matters also adjourned beyond the election period, again 21st of this month. So it is very clear that there's a very clear decision of the judiciary in cohorts with the DPP and government to have all political leaders, first of all, not obtain bail during this electoral period, and again, for them not to participate in this election.
We want to know the situation of Sauda Madada, because last time we were in court and the court ordered prison to bring a general report about the health of Sauda Madada, or to access that report.
Well, court has of recent said that it is convinced it received a report about the health situation of Councillor Sauda Madada, but we've not chanced that report. We are entitled to have a copy of the report. It's the reason we do not believe that Sauda Madada is in good condition. Otherwise, why would they not give us a copy of this report to appreciate the situation of our client? The application was by us, our lawyers. That us lawyers have not received the report, but the court has maintained it. Well, albeit that sometimes these are private matters. It can only be a private matter if there is protest from the accused person, that it may not be disclosed even to the agents, not even family, because this is a report that the family, the mother, sister and other family members have requested for. So it cannot be a preserve of court. It remains now really a mystery of whether Sauda Madada is anyway in good condition, because that she cannot even come to court, as we witnessed, says a lot about her health situation. So we continue to pray that she gets better if she is alive, but we will not be surprised if anything happened.
Is there any player you are likely to make, because we have seen people dying in prison? We saw your fellow lawyer, Bob Kasango, lost his life in jail.
No, it's a plea to the judiciary. They have continuously really not followed the law, and people have died out of the negligence of courts in following the law in matters where people deserving to receive specialized treatment are left in prisons. We saw the German national, who was in Kalanga, he came to court even on stretcher.
Yes.
They told the justice, then, that this person, the doctors say, may not even spend more than 2 months alive. We had senior reports on the Honorable Segirinya Muhammad, and this motivated his release. And again, as doctors had stated, that he would not stay for long. He died after the court prisons and the conditions had cut short his life span, because there was no specialized services or treatment in prison. We've seen colleagues like Bob Kasango, again, upon court's refusal to grant him the permission for specialized treatment in Nairobi, because this is where his doctor was, he died. And all these things are some of those issues that, when we are amending guidelines that guide bail applications or decisions and bail applications, these are the issues to look at, not the issues as determined by the political speeches of the president, who continuously states that bail should not be granted. So the tilt is towards a political question rather than the real issues that will determine someone's qualification for bail, including special circumstances. Sickness is part of the special circumstances that ought to be considered when determining a bail application, and courts should uphold that.